Hi, I'm experienced U.S. trademark attorney Morris Turek. In this video, I'm going to talk to you about the U.S. trademark application process. It's pretty common for clients to ask me about the U.S. trademark application process and what they should expect once their trademark application is filed. Needless to say, the road to registration can be very bumpy at times, more so for applicants who didn't perform a trademark search or failed to seek an opinion from an experienced trademark attorney regarding the eligibility of their trademark for registration. If you're thinking about navigating the trademark application process yourself, it's even more important that you fully understand the entire process to maximize your chances of successful registration with the United States Patent and Trademark Office. In order to begin the U.S. trademark application process, you'll need to log in to your USPTO account. If you don't have one, then you'll need to create one on the USPTO's website. It's completely free of charge, and it shouldn't take you very long to get up and running. Once you're logged into your account, you'll be able to start preparing the USPTO trademark application form through Trademark Center. The USPTO actually provides 5 different trademark application forms from which to choose. One of the forms is used to apply to register a trademark on the principal register, which is what the vast majority of people want to do. The other 4 forms are used to apply to register a trademark on the supplemental register or to apply to register a certification mark, collective membership mark, or collective trademark on the principal register. These 4 forms are used far less frequently than the form used to apply to register a trademark on the principal register, but it's certainly possible that the nature of your mark will necessitate preparing one of these forms instead. Because these forms are not commonly used, this video will only address the U.S. trademark application process as it relates to the filing of a trademark for registration on the principal register. Once you've carefully prepared the application form, you must file it along with payment of the USPTO filing fee, which is usually done with a credit or debit card. Immediately after submission, you'll receive a confirmation screen displaying your application serial number and an option to download your filing receipt. You'll also receive a copy of the filing receipt via email. After filing your trademark application, it will be a few days before it's available online for public viewing and access. You should use TSDR to check the status of your application and to periodically monitor its progress. As a result of the vast number of trademark applications filed every year, it will be many months before the USPTO assigns your application to an examining attorney. Until then, your trademark application just sits there waiting patiently for an examining attorney to review it. Once that day finally arrives, the examining attorney will examine your trademark application for both completeness and compliance with all of the USPTO's rules and regulations. The examining attorney will then determine whether your trademark falls into any one of the numerous categories of trademarks that are legally prohibited from being federally registered. Finally, the examining attorney will conduct a thorough search of the USPTO records to determine whether there's a likelihood of confusion between your trademark and another trademark in a pending application or existing registration owned by someone else. At this point in the U.S. trademark application process, one of 3 things will happen. 1. If the examining attorney finds nothing that would bar registration of your trademark, then your trademark application will be approved for publication. 2. If your trademark application contains errors or omissions, or if the examining attorney determines that your trademark is ineligible for registration, then you'll receive a trademark office action explaining why your application can't be approved for publication. In order to prevent your application from going abandoned, you must file a response by the deadline stated in the office action, or a request for an extension of time to file a response if eligible. If you're able to successfully overcome all of the issues raised in the office action, then the examining attorney will approve your application for publication. If you're not able to, the examining attorney will instead issue a final office action, at which time you would have the option of filing a request for reconsideration with the examining attorney or a trademark appeal with the Trademark Trial and Appeal Board. 3. The examining attorney issues a letter of suspension, which puts your trademark application on hold until the situation that occasioned the suspension is resolved and your application can be approved for publication. Soon after your trademark application is approved for publication, it will be published for opposition. This is the point in the U.S. trademark application process where anybody throughout the entire world can file a trademark opposition against your application if they believe they'll be harmed by the registration of your trademark. If an opposition is filed with the TTAB within the 30-day publication period, or within the extended period of time granted by the TTAB in response to a requested extension of time to oppose, then your application will be put on hold until the opposition is dismissed. This could take weeks, months, or even years. If nobody filed an opposition against your trademark application, or if the TTAB ultimately dismissed the opposition, and your trademark application is based on Section 1A, Use in Commerce, or Section 44E, U.S. application based on a foreign trademark registration, the USPTO will issue the Certificate of Registration. However, if your trademark application is based on Section 1B, Intent to Use, the USPTO will instead issue the Notice of Allowance. You have 6 months from the Notice of Allowance date to file the Statement of Use. If you can't file the Statement of Use within those 6 months, you can obtain another 6 months by filing a request for an extension of time. You can purchase up to 5 extensions of time, 6 months each, before you must file the Statement of Use. The examining attorney will review the Statement of Use to determine whether it's in full compliance with the rules. If so, the USPTO will issue the Certificate of Registration. If not, then the examining attorney will send you an office action explaining why the Statement of Use can't be accepted. In order to prevent your trademark application from going abandoned, you must file a response by the deadline stated in the office action, or a request for an extension of time to file a response if eligible. If you're able to successfully address all of the issues raised in the office action, then the examining attorney will accept the Statement of Use and approve your application for registration. If not, the examining attorney will instead issue a final office action, at which time you would have the option of filing a request for reconsideration with the examining attorney or a trademark appeal with the TTAB. Again, I'm experienced U.S. trademark attorney Morris Turek. If you would like to consult with a trademark attorney about the U.S. trademark application process, or want to explore the possibility of registering your particular trademark, please contact me today for your free consultation. I look forward to hearing from you soon.